Good morning, everyone. Louder? Here? Well, my name is Andres Piazza. I'm the general manager of LACTLD. We are also, well, as Eduardo said, pleased to be here interacting with this amazing set of partners here in DC, also with Center and the PAR and the local actors that jumped in, and it seems to be a really nice panel. So at the beginning, I wanted to introduce, and you have the bios of every panelist here at the sheet. So I just plan to say name and affiliation, and maybe each one of you can introduce yourself in a way that you feel comfortable. So we have Frank from Microsoft. We have Byron from .ca, the CIRA. We have Jörg from .de. And we have Felix, who is a consultant. Well, he will explain more, maybe. So the general idea is to have a discussion in privacy from the industry perspective, not only the domain names industry or the DNS, but more in general the producers and the service operators of the internet, and trying to discuss the more focused topics related to regulation, to the GDPR, to the privacy shield, to the difference between the European and the US perspective, the Canadian situation, then the case of Microsoft being a cloud and a software company and different based in the US. Then we have an expert, a legal expert, that can cover with a more general approach, and then the objective of the panel is to have a conversation and interaction. I will try to throw some triggers, but I hope the audience is also focusing, participating, and you are. We want you to participate, to ask questions, to make comments, even if you wish. So I just want to give the floor. Let's start with Jörg.
Okay. Not open yet. Can you hear me by now? Well, if I would have turned it on, then it's all about privacy, you know.
No recording.
All right, yeah, thanks, Andres. My name is Jörg Schweiger, CEO of DENIC, managing the German country code top-level domain. So my perspective is clearly the one of a European-based registry operator. And, well, I was asked, or I was supposed to give an opinionated statement about the impact of data privacy on a registry operator. And, well, I felt that the matter is rather complex, so I thought probably it would be very easy and helpful to answer some basic questions first. So basic questions like who is really issuing policies and laws that are relevant? Which kind of policies do we need to take a look at? And finally, what as a registry operator we really do need to do? Okay, so first, who is issuing policies? Who is issuing regulations, directives, and laws? Well, what first comes to mind is for sure the country your business is in residence. That is not really very surprising. But then there's supranational institutions like the European Union, for example. And then very interestingly so, it's countries, those citizens you are doing business with. And for sure, I wouldn't want to lack on mentioning ICANN at least once, so we need to talk about ICANN with respect to policy as well. Well, which policies do come to mind, and I think for sure, first there's GDPR, so it's General Data Protection Regulation, and that regulation has been issued by the European Union. It has to be implemented by all European member states by 2018. And you need to comply with those regulations if you are a member state or doing business in those member states. But more than that, you are also impacted if you are doing business with an individual residing in one of those countries, which I think is very interesting to see. Then for sure we do have RDAP. RDAP just standing for Registry Data Access Protocol, where that is just a protocol. There is a so-called operational profile that has been released by ICANN. And the profile is setting up clear clauses on the data you need to provide on your registration data. And that, by the way, has to be complied with by each and every GTLD or ICANN accredited registrar. Then what may come to mind is Privacy Shield. So if you are transferring data that is personally related to the US, then Privacy Shield is something you need to take a look at. And I think Felix is going a little bit more into detail about all that. And finally, what may come to your mind is the e-privacy directive as well. But as far as I think, we are not concerned by the privacy directive because that would pertain more to over-the-top businesses like Facebook, Google, and so forth. So finally, coming from a European-based perspective, what do I think? What are the fields one need to take a look at if it comes to data privacy? Well, we should look into our registration data we do record. We should take a look at information that is being provided over those data, like WHOIS and RDAP. It may even come as far as that we need to take a look at zone files, because zone files do include IP addresses. They sometimes do have domain name strings in them that resemble personal real names. You do have to take a look at stored DNS data, because those may include information about the querier's origin. And finally, even regular DNS traffic. You may not think that, but DNS traffic, for example, there may be email certificates within that DNS traffic, so there's personal related data in that traffic. And finally, to sum it up from my first statement, for sure you need to take a look at all your services, all your supplemental contracts, your underpinning contracts, your terms and conditions with respect to data privacy issues.
Thank you very much, Jörg. We will come back in several of the topics that you touched. I wanted to give Byron Holland the floor. He's also a CCTLD operator, CIRA is. They also have other operations in the DNS, and they have several similar challenges of what Jörg described, plus this situation this particular situation of Canada and its own regulations and the relationship with the UE and the US regulations. So, Byron, you're next.
Thank you very much, and good morning, everybody. Byron Holland, I'm the president and CEO of CIRA. Our primary mandate is to operate the .ca top-level domain. But over the past couple of years, as we've seen the domain name industry start to mature in terms of growth and to flatline to some degree, we took on a couple of new lines of business to help supplement our revenue streams and ensure that we could effectively deliver our primary mandate. And to that end, we developed a registry service that we can sell to other registries, as well as a global DNS Anycast infrastructure. Now, .ca, of course, is the primary tenant on both of those, but we built multi-tenant environments that can support other people's registries and other people's Anycast needs. And that's put us in a very different business than we've spent the last 15 years in, which is just supporting .ca. And as such, we have had to start to pay close attention to other countries' privacy regimes, rules and regulations in general, but certainly privacy regimes. Now, coming from Canada, we always are typically in the position of having to have a foot in two different worlds. We share common cause and background with Europe, but of course we share the continent with the US. And you know, as we say in Canada, when the elephant rolls over, the mouse has to pay attention, right? So for those of us trying to do business in both places, we have to make sure that we build systems that can support two different regimes. And I believe in particular, organizations like ours, but others, we find ourselves in an interesting place today, in a sense, at the intersection of two competing ideologies, one originating from the US and the other from Europe, sort of the two of the great world economies. And those two are really driving global standards. That said, of course, I also have to comply with my own national regulations. Now, I think interestingly, given the shared histories between Europe and America, they've really quite diverged in terms of regulations and policies, at least from, in a sense, a philosophical perspective. You know, I think the US's history or America's history of constitutional protections from government tends to be quite different than the approach the EU has taken, which is government protections from industry. And that's really quite a philosophically different approach in terms of privacy protections for citizens. And I think interestingly, while citizens are protected, they're being protected from two different very types of entities. You know, to some degree, the Europeans are protecting from the rapacious private sector capitalists, and in the US, it's from the omnipresent eye of government, which, of course, is somewhat ironic, but that's a different conversation. However, regardless of what I or we in the industry think, the fact remains that as operators of registries or other internet service providers, we're challenged by this duality and the changing nature of that duality, be it the Privacy Shield today or General Data Protection in 2018. You know, for registry operators like ourselves at CIRA, I mean, we resolve 800 million DNS queries a day, 4 or 6 million whois lookups. You know, our day is fairly full already, and I'm sure that seems like not much to Jörg, but nonetheless, it fills our day at CIRA. He has many more millions of domain names than we do. But as CIRA, with a set of, you know, sort of growing global ambitions for our other lines of business, I thought that our experience with a foot in both worlds hopefully would be helpful here. You know, I think we do occupy, as CIRA, a little bit of a unique space, given we have our own privacy regime, but we live in the North American continent, but are doing a lot of business with European companies. And as we built our new registry platform, we very much had to take that into consideration. In fact, I'd say we've been forced to deal with both a changing and complex set of regulations and had to literally, from the very planning stages and architecture stages, build the platform and applications to be as absolutely flexible as possible. Now, we had to do this, and of course, in doing that as an operator, that incurs time, money, resources, et cetera, to mitigate against effectively an unknown future from an evolving privacy landscape, but also, at the very least, a dual privacy landscape between the EU and US, not to mention my own at home. The good news as a registry operator is that in doing so, I think that we've created a platform that's incredibly flexible, that's end user focused, so developers don't have to deal with making changes to satisfy privacy regimes of one or the other, that the end users can. But that's a significant burden through the development stage, through the planning stage, from an architecture perspective. So there is material overhead associated with being compliant in both regimes. You know, I think essentially the takeaway from this for us as an operator, a day-to-day operator, is it takes a lot more effort, significantly more thought, significantly more resources to develop these kinds of platforms. But as much as possible, we've tried to make it a positive in that if we want to do business in these evolving privacy landscapes, we have to create an environment that's flexible, ideally end user driven or customer driven as opposed to developer or operator driven. It costs more, takes more time, certainly takes more planning, changes the architecture at the very, very base level. However, at the end of the day, I think there's significant opportunity in that if you can build that kind of a system and treat it almost as a positive in terms of creating a very flexible environment, we believe we, in a sense, have turned lemons into lemonade with our platform. So the takeaway from me is it is more complicated. It is, to some degree, a pain to have to deal with the evolving and dual nature of these two landscapes. But on the other hand, if you take up that challenge and create the environment, I think there's a lot of opportunity for organizations that do that with a view to the future.
Thanks, Byron. When you are saying about having a foot into two different worlds, it reminds me to Latin American region also, and some of the managers of the CCs of our region will feel the same. It's some of the challenges are also similar. Maybe you can comment later from your perspective. Now we have Frank. Frank, it's different, your approach. You have a US-based company, different industry, and you are oriented in consumer affairs. So you have a lot to bring to this conversation. So
sure. Well, first of all, thank you very much for having me here. It's you know, as interesting as it may be for you to hear my perspectives, it's very interesting to hear your all's perspectives as well. So my name is Frank Torres. I work in the Government Affairs Office here at Microsoft. But even before I was working in Microsoft, I was working on the privacy issue. And I remember when I first started my career, you couldn't gather 5 people in a room here in Washington who were working on privacy. Of course, now there's a big conference that happens every year here, and there's 5,000 or 10,000 company members, and probably that number of individual members, all with responsibility of privacy in their respective companies. So the issue definitely has evolved through the years. And it's not just, I think, a dual for companies like Microsoft. It's not just having a foot in 2 doors. It's having a foot in many doors, as more and more regions and countries have taken up privacy as a key issue to protect their the citizens in their countries, and so that puts companies like Microsoft in kind of a challenging position, but not necessarily in a bad way, because as the issue has evolved for regulators, both here and abroad, so too has it evolved in companies, maybe at different speeds, but nonetheless something that more and more people recognize as something is important to deal with. And certainly in Europe, you have the notion that privacy is a fundamental right, It's taken folks in the United States a little bit longer to kind of recognize that, but then you've got the two different perspectives, as Byron pointed out, of protection from commercial interests, and then what do we do about government surveillance? With that in mind, I did want to focus a little bit on the Privacy Shield, but also talk about how we kind of got there, which brings us back to the government surveillance issues. So, Privacy Shield was really something that was top of mind and very important for us. Just the importance of the global data flows, both for U.S. and European companies, and across really all industries that rely on that sort of international flow of data to serve both their business needs as well as their customers. And so our view was that the Privacy Shield really establishes a new standard of protections for Europeans' personal privacy data, which we thought was important, especially as we evolved as a company and recognize privacy as a fundamental right. And we think the Privacy Shield addresses that. So as a responsible stakeholder, we've been supportive of that law. We've certainly been engaged in Europe around discussions of the GDPR, the various privacy directives. And for this reason, really, our business doesn't succeed, and I would venture to guess if you ask Google and Facebook and the other companies, their businesses don't succeed either unless people trust you. And privacy is fundamental to that trust. And how do we get to that? That there's many, many factors, including transparency and accountability, and things like the Privacy Shield, we think get us there. Of course, there are various aspects of the Privacy Shield, happy to get into those later, redress, the role of the DPAs, the data protection authorities. There's also provisions on data retention and onward transfer that we believe are important. And there's an annual review provision that plays this critical role, and that's it allows for stability, but at the same time the flexibility. One thing that we see time and time again is sometimes our laws simply don't keep up with the technology, and that presents a challenge to companies and industries. You're sometimes put between what we say here in the United States, a rock and a hard place, where complying with one country's laws may put you at odds with another country's laws. And we saw that recently with a warrant that we were served, and we challenged the U.S. government on that, where complying with the U.S. warrant would have violated Ireland's laws. So, how do we begin to address those types of concerns? So as a practical aspect, though, Microsoft is a company, we are a business, and there's certain compliance things that come into play with the passage of things like the Privacy Shield. But we found ourselves in perhaps a slightly different situation than perhaps some other companies, in that we've had a comprehensive privacy program for more than a decade as a result of, well, some people say here in the United States, our privacy laws aren't necessarily as robust as those in other countries. I would beg to differ. We take a slightly different approach. We do it more sectorially than perhaps in Europe, where it might be more comprehensive. And we have a very rigorous enforcement actions, and our Federal Trade Commission, or the FTC, who has responsibility in this area, through the years have taken on most of the big companies, different aspects, and that kind of sends a signal to the rest of the industry. And in our case, we were subject to one of the cases, enforcement actions that the FTC brought, and it was basically around some of the things that were in privacy statements. And so the need to be clear to your users in what you say is important, but the example there more is that we do have a strong regulator that takes privacy as very important. So that helped, drive our development of our comprehensive privacy program. But as a global company, we needed that to scale. It's kind of anathema to any large company with a global presence to try to comply with the laws of the nuances of laws around the world. You tend to take the strongest laws that there are, say the European privacy regime, and comply with those, in a way, if you're smart, that then also meets the standards in other regions. So, it's important for us we have a desire to kind of scale when it comes to these sorts of things. So what does all this mean? It means that we had a robust privacy program in place, but with the Privacy Shield, we did have to make some adjustments because of the requirements there. So we did revise our privacy statement to meet the transparency requirement. There's specific links that you had to put in and specific words that they wanted you to use, in part because once you said those things in the privacy statement, that triggered the ability for the Federal Trade Commission to actually enforce, to make the Privacy Shield enforceable from a U.S. perspective. We also included, or we were also supposed to include a reference to your redress mechanism. Now, in the Privacy Shield, you could opt to do what we call an alternative dispute resolution, where you use perhaps a third party, such as trustee, an independent third party that if a customer has a complaint they can go to and seek resolution, or you could make yourself subject to the national data protection authorities in Europe, and that's what we opted to do in that case. We have a presence in Europe. There's no denying that we have a strong presence in Europe. However, we also recognize, I think the Department of Commerce and the negotiators also recognized that there are smaller companies that perhaps ADR is a more appropriate way to address redress. There's also the question of the supply chain and what do you do about compliance with those companies that you may have contracts with to help you service your customers, and that there's provisions that say that your contracts have to provide that they also have to comply with the Privacy Shield, and there's some grace periods if you sign up for the Privacy Shield that allow you to we understand there's some administration that goes into that could take a little bit of time to do. But the last thing I want to get to here is how did we get here? And not only do I work on privacy, but I also work on efforts by the company to address the government surveillance issues that I'm sure all of you are aware of, the Snowden revelations that kind of rocked things here in Washington, definitely, and in the United States generally, about government surveillance. And what occurred to us is the need for a rule of law that governs how this works in today's world, that allows for recognition of privacy and human rights, but at the same time allows our law enforcement to do their job to keep us safe as a society. But what's the give and take, and what's the appropriate structure for that? And this is the area where we found that, at least here in the United States, our current legal framework certainly hasn't kept up with technology, that it's easy for law enforcement to go out to Silicon Valley or come visit us in Redmond to do kind of a one-stop shop to get information about our customers. We think much better to go to the customers themselves where appropriate, especially in the enterprise or company space. There's certainly more that needs to be done on an international basis to address this. As companies are global, companies are based in the US, we've got companies in Europe, we have law enforcement agencies that are looking to cooperate even more to protect the citizens in their countries, and how do we address that? But the reason I raise this in this context is we got to the Privacy Shield because the safe harbor, which existed before the Privacy Shield, was challenged because of the revelations around government surveillance. And so, to me, the two go hand in glove, and there's an expectation that even the Privacy Shield could potentially be challenged under the same grounds. Now, we think there are protections in the Privacy Shield and assurances from the U.S. government around some of the surveillance activities, but nonetheless, that is still out there. Microsoft actually has taken several legal actions against the U.S. government and our law enforcement agencies, almost on a test case where we think the law needs to be clarified. The court recently came down and said, U.S. government, you don't have the ability to extend your warrants overseas. You actually have to go to those foreign governments and work out your agreements with, either work through existing agreements with those countries or create new ones. This is something that Congress needs to address. You can't just simply have this authority. You wouldn't be able to physically fly to a country like Ireland and simply break down somebody's door and get the data that you want. Go through the legal process. We've also sought changes in U.S. law, and we continue to do so to address some of these concerns. And so, part of this is also respecting the sovereignty of other nations. In this global environment where we care about data flows, where consumer trust is important, all these factors come into play.
Thanks very much, Frank. And you brought food for thought and for the reactions in the rest of the panel. If you weren't bringing this surveillance thing and the relationship with, or the challenges for the Privacy Shield, I would have done so. On the other hand, I hope we talk more about the robustness of the issue that you raised about the robustness of the U.S. regulatory framework and its ability to enable innovation and comparisons between frameworks, maybe in the future, maybe after Felix. Felix can provide us a broader legal perspective. He's a consultant. His company has offices in Europe and in the US, and they advise in the different frameworks, in the different regimes. Maybe you can explain that better, so go ahead.
Thank you, Anders. My name is Felix Wittern. I'm a partner at Fieldfisher. I'm a German partner, as you probably can hear. Currently working from the Silicon Valley office we have, because most of our clients, or many of our clients, are actually international clients doing business in Germany. And we advise them on many things, but we're basically the leading firm on the privacy issue, where we have one of the biggest European teams solely advising on European law. And this has been an issue that has, grown, as all of you have mentioned, throughout the last couple of years significantly. I've worked on privacy for the last 20 years, but actually I have to tell you that probably in the last 3 or 4 years, it has really risen in its importance. And as you can see, the entire meeting today is starting off with privacy, because it's so much affecting everything we do in many fields. Maybe even some of you are not even there yet in really realizing how close things are coming to many companies that may actually not have that much of personal data. Most would think, well, if it's health data, or if it's financial data, or if it's political information, or other sensitive data, then it's really a problem. But for you, as if you have a TLD, there's not that much of very critical information at the first view of things. But then, if you go into second level, and you look into what you have and what the obligations are, and I'm going to talk about them for a second later, there's actually quite a bit that's critical. You've talked about government surveillance, about the government access, and that's not just the US, actually, although everyone has been looking at the US for all the access they are taking into data, and the Schrems decision, which you've quoted, also has been heavily hitting the US for their governmental activity and the surveillance of data flows. However, many of you know there are others as well, and numbers show, for example, that again, my home country, Germany, has a very active police, and so there are a lot of warrants that come up, and actually a lot of the work is on the surveillance side in coping with them, and that could be something that's quite important for many of you in the room as well, where you get inquiries. How do you actually deal with it? And is what you're doing correct, or is it basically just, well, giving data to those who are the loudest? And there could be, what I see from many of my clients is that they're willing to provide information, and they've done so for years, to state authorities, where it may be that if this really was looked into by a court, it could actually be an issue. So that's something to think about. Another topic that's interesting is, what is the data you are actually collecting? Its name, its address, and is that protected? So for those who are not in the EU, you may say, well, you know, I don't care about the European laws because I'm providing my service from someplace else. And the problem is, which Jörg already mentioned, with the new upcoming GDPR, the new regulation that we'll have in place soon, you'll have an issue, because all of a sudden every customer that you have in Germany or elsewhere in Europe will be the one that actually has your company under European law all of a sudden. So, while in the past you could say, well, I don't really have to care about it. Specifically, if you have a smaller domain, one of the GTLDs, not saying that they're small, but maybe your customers are not country-specific, but they're interested in your domain because of what the domain says, or because of that domain name. All of a sudden, you have to comply with those laws, and the GDPR is not only going to be effective in 2018, it's also, the fines in there are significant. So while currently a breach of privacy is not really an issue, that because it's not very costly. You know, everyone likes to comply with laws, but then you take a business decision whether you are going to pay 2,000 euro for a breach, or whether you're going to change all your systems. And then you may just say, well, you know, in that case, we'll go for the fine. So that's what I'm seeing, because many fines are not even issued. Now, this is changing, because the fines are going up to 20 million euro. Now, that's significantly different, and may actually change the perspective of many towards how you want to comply with the law, and what are you actually going to do. So many of our clients now do this GDPR readiness assessment, which is looking into, are you really there? In May 2018, the GDPR will come fully into effect all across Europe. There's no additional way of stopping it anymore. So you will have to be compliant by that time, and you will, or many of you will need to change some of the processes you are applying for your companies. So that's what you're facing. The other thing which Frank mentioned is the international data transfer itself. So we have the GDPR, the other one is if you transfer data outside of the European Union, it has to go to a place with an adequate level of protection. And there are various ways of coming to that adequate level for that data. One of them is to have model clauses which would need to be signed by the data subject and the one that's importing the data, or and that's very difficult if you have many customers. It's basically not possible to use that if you have a large customer database, at least with every customer. There are ways around it, and it can be solved. However, that solution, which has been the only solution since, well, not the only solution, the most favored solution for many before Privacy Shield came into effect for only the US companies. So actually it's only covering a small subset of those who do carry out international data transfer. However, model clauses are also under scrutiny because the EU Court of Justice is currently looking at it. Schrems has taken forward the EU model clauses now, and it could well be that those will be held to be invalid as well, because the problem in there is the same that we saw in Safe Harbor, which is there is a potential access by government to the data. And that hasn't been solved by the EU model clauses, and many also say that the privacy shield does not sufficiently cover that. So although, as you heard, Microsoft is quite optimistic about it and really likes it, there is a lot of criticism around it by many privacy advocates. And I'm pretty sure it's going to go to court as well. The Article 29 group, which is a group of regulators in Europe, has been critical about it. And actually, one of the regulators in Germany, they're always very happy to push themselves in front of everyone, has already said that they are going to take it to court. So, or at least they're taking it forward. So whether Privacy Shield will be what we're seeing right now in a year's time or not, is going to be interesting. However, many also of our clients are rushing towards it, and it's not a bad solution at all for your international data transfer at this moment. Just to mention, there's another third way of doing it. So I've talked about the model clauses, I've talked about the Privacy Shield. There also is the opportunity to go for binding corporate rules or binding safe processor rules, which is a rule set that a company basically gives themselves and says, if we have those rules in place and we are accepted as safe processors, then we can do it for all our customers. And there could, although currently it's mainly used by large companies because it's quite a project, it could still be an interesting one to look into. So those are the international data transfer things. And just to mention one more thing on upcoming decisions, I've talked about the fact that model clauses are under scrutiny. Another one that's quite interesting, and we'll probably still see this year, is on IP addresses. So when you establish an internet connection, everyone will need IP addresses to establish that connection. And if you ask a US company, they will all tell you, well, you know, this is not personal data, it's just a number. And if it's a dynamic IP address, it's actually not even absolutely clear whom it should be allocated to. And only the telecommunication services providers are able to do that. The view in Europe has been a different one, and I'm pretty sure that the European Court of Justice will say the same thing, because they've already given indications that they will, and say everyone that's collecting IP addresses, and you are collecting them, again, as you're just establishing your connection, is actually collecting data, and then, as I said before, that's going to be European data. So there are several topics that are quite hot. And just while I'm sort of at it, and you can't talk because I'm talking, the other one, the one that you've touched on is the conflict between the GTLDs and ICANN, where ICANN is, has requested that personal data has to be collected within their database. That's an issue as well, because the personal data, if it's not a company, it's personal data if it's individuals' data that's registering. And there's a very strong view in Europe that this data cannot be shared or publicized just for everyone, but there should be the decision by each individual whether they want their information about the admin C, etc., which is in the WHOIS database, whether they want that published or whether they don't want it published. And I think we need to have a solution that actually allows for collecting that information, because you may need it for government access and you may need it for contractual obligations, for fulfilling contractual obligations. On the other hand, not to display it. And it would be interesting to look into how those data flows should be established. Okay.
Thanks, Felix. Well, we have presented the regulations and the requirements that have been, or that should be met for operators and service providers, which was originally the purpose of the panel, but we have more than half of the panel to discuss these issues that have been raised, so we have really a good opportunity now. Felix raised some issues regarding the problems that the privacy shield could have. Maybe in the future I want you to explain more about that, and about the last thing that you mentioned regarding WHOIS and the data transfers for the registries. I want also the colleagues from registry operators to tell more about their approaches with that. Also, maybe I should ask personally questions, so I will go with Byron and then with Jörg with this. After reactions from the panelists, I will go with the floor to the rest of the audience. So Byron and then Jörg, maybe you can react to this, and also to, if you may, the concern about which framework of the ones that are in the future being faced are the ones that, or which are the topics that may allow you to innovate, to create, to grow, to keep on the path of growing, for example, in the DNS industry, and the same for Microsoft. So, please.
Thanks. Well, given the sort of the opening comments that I made about what it takes to operate a registry and satisfy international clients, I want to thank Frank and Felix for actually truly making my point for me. When you listen to the two of them talk in a highly educated, deep and meaningful way about the various policy regimes, regulations, and drill down into it, every one of the comments they made, in a sense, has to be translated into code and developed. And that has become an incredibly challenging and complex task, which is essentially the point I was trying to make in a little lighter way. But when you listen to them, you really get a sense of how do you operate in that environment? How do you build products and services that satisfy all of those demands? And as an entity or an operator that had a legacy environment, I can tell you, it would have been almost impossible to satisfy all of those demands, particularly in light of the fact that it's an evolving landscape and a spectrum. So yes, I might be able to do something that satisfies for today, but what about next week, next month, next year, let alone 2 years out? And that's one of the reasons we essentially had to take the decision, you know what, if we want to play in the international space, we have to completely redefine how we think about being an operator and what kind of service we develop. And that has profound obligations, literally from a planning and architecture perspective, let alone a development perspective. Let me give you just a very, very, very simple example. WHOIS. Most of us are pretty familiar with WHOIS. In Canada, with our privacy regime, which tends to share common cause with the EU's privacy regime more than the American privacy regime, we have to mask personal WHOIS data. So we have individual and corporate registrants. For individuals, we have to mask all their private data. But if we want to be an operator that plays in the GTLD space, which we do, we have to make that available based on ICANN rules and regulations, et cetera. So this is a very straightforward example, but those are two very different ways to approach what we do with WHOIS data, and we have to satisfy both sides. So in the next generation registry, which we've just put on the market, literally everything has, to simplify it, flags and tags associated with almost every action, almost every field, and are user determined. So we don't have to go back into the development shop, and for those of you who run operations, you know, create a ticket, prioritize it, do the analysis, drill down into the business requirements, et cetera, et cetera, et cetera, before somebody gets on the keyboard, tinkles the ivories, does the code, pushes it to test, dev, et cetera, and back out to production. Ours is completely user enabled, so the end user tags or flags, mask, don't mask. But having run a legacy registry, I know how difficult that would be. And again, any operator who's trying to build on top of legacy infrastructure, That's how you get spaghetti code, right? And this is a classic example of if you want to build a spaghetti system, just listen to what these guys talked about. Legacy environments are in deep trouble if they're trying to hit those moving and evolving targets on top of legacy infrastructure. And while on one hand, I sympathize, no, I don't sympathize, I empathize with folks who have to try and do that, but on the other hand, it provides significant opportunity, I believe, for operators who are willing to take on that challenge and leapfrog the legacy systems, which is where certainly we are, and I assume others are too. But it is a deep challenge to meet all that you have just heard about between Frank and Felix.
Thanks, Byron. Going to Jörg, similar discussion approaches and adding to the translation that Byron wanted from these legal demands into code, adding on top of that, Jörg, the sustainability, the economic sustainability that is also a challenge when you meet all the rest. So reflections on what Byron said, and even with that.
Well, actually, a lot of thoughts coming to my mind. First, let me pour some more oil into the fire. And that is, we've been talking about general data protection regulation and the burden that is being posed by all of you who have to deal with that. Here's the oil. The oil is that there are more than 60 opening clauses on GDPR. So GDPR, as it is, has been a regulation, and a regulation needs to be implemented by states as is, but obviously there are opening clauses. So what I'm saying is there may be differences within the European states. So, Byron, that is the lucky news. You might even be enforced to produce even more spaghetti code. On the other hand, being within that jurisdiction, for me, it's a quite comfortable situation because I do have to stick to that regulation anyway. We are, for example, deriving opportunities from those challenges. So, for example, what we've been doing as a registry, we are offering escrow data service, or we are offering data escrow services for European customers, so that you do not need to be concerned with privacy shield issues. So that is really offering business opportunities for us. Finally, what I'm tempted to say is, well, if you are being confronted with service providers who have to cope with all that different kind of regulations, well, opt for CCTLD. Because we may be in a very comfortable situation as opposed to GTLDs, because we do not have to comply with all that different requirements. So you may really very well ask, as a GTLD operator, how would I comply with the RDIP operational profile in parallel with GDPR? We are not concerned with that as CCTLD managers. So it might be a good choice to, well, consider if being a CCTLD operator might be a competition advantage, really.
So,
Yes, please, if you want to react, go ahead.
sure. So I think there are different aspects of this, and certainly some of it was covered here. You know, whatever the regulators require, you know, you've got to consider the code and kind of the internal implications and what that means. And certainly for a large company like Microsoft, we've got a pretty robust team, as I said, who kind of do that. And sometimes they complain about it, but if it's a requirement, they do it. Others might not be in kind of that situation, and so certainly it would be a larger burden. But like I said, that there are other aspects of this, and when you talk about innovation, you know, how do you make sure that a regulation or a policy is appropriate? And part of that is, you know, engaging with the regulators or the legislators to make sure that the laws themselves or the regulations themselves are sound and something that makes sense. Of course, that gets to be a challenge because technology is so rapidly changing. Like I said earlier, sometimes it's very difficult to try to anticipate today what may happen. I used to say 10 years from now. Now it's more like next week. Something could change. And how do you anticipate that? Then on the other side, though, you've got customers, including enterprise and consumer customers, who are concerned more and more about the privacy and security of their data, both in the commercial setting but also against government surveillance. And how do you address those concerns, again, going back to the trust factor, so that the last thing you want is, as a business like Microsoft, is a large customer to say, there's just too much uncertainty. We don't know what to do. And so in some cases, we actually, don't mind regulation where it's sound, where it makes sense, if it can help provide those assurances to our customers, whether it be enterprise or consumer customers, that there are kind of rules in place that there's some stability or some certainty. It's all going to get even more challenging as we move into, kind of the new wave of technology coming out. I mean, there's talk about big data and all sorts of things, which, it's also very important when we talk about innovation to not forget that there are benefits to all this, right? I mean, we're doing this in large, if not in entire part, to benefit, our customers and hopefully society around some of the great innovation and tools that we're able to provide. I would think other companies would say the same thing. So how do you kind of balance all of these things going on at the same time? It gets complex and challenging, but at the same time, and the providing of the benefit is worth kind of trying to tease out and resolve.
Thank you, Frank. Before going to another reaction from you, Felix, I encourage the audience to interact, and there is a question that has been waiting there. So from the lady, you are allowed to question and comments and even more questions because I got you holding there.
Okay. Hi, Liz Svinberg from PIR. So Felix, you mentioned something that I spend a lot of time thinking about, which is who is and our obligations as a GTLD registry operator to collect registrant information and publish it in our who is, and we are a thick registry. My question is there a specific opt-out for registrants, citizens in the US, we would call them consumers. In other words, by registering a domain name and providing the information, knowing, and we publish certainly on our website, that we are obliged to publish this information in the who is there a recognition of the concept of opting out or opting in, one, and does the fact that there are privacy proxy services available to registrants throughout the DNS and certainly for GTLDs, does that in any way mitigate the registry's obligations under the various privacy regimes?
Okay. So actually, that's a very, very extremely good question, and I hope I can help a little bit in finding an answer. Maybe we can work on it together. The information, the customer will know that their information is published, and that's about the first step is about transparency. So that requirement would be that you have to state clearly what you are intending to do with the data. We could argue that the consent is sufficient. So if the user says, yes, I'm happy with it, then it's published. The question is what happens if he doesn't want it? Can you say, well, then you won't get the service? Which is often the response you'll get in the US as I've just moved here, I've signed a lot of contracts I didn't like, but then they told me, well, if you don't want it, don't sign it and you'll never get it. So the one solution could be you work with consent, but it's not really a voluntary consent. It would be either you agree or you don't get the service. That's one way of collecting it without changing anything in the code, by the way, because what you do is you just tell your customers, or the potential customers, you can't come to me. If you're not willing to do that, and there are also legal implications on doing this, because maybe that consent wouldn't be valid if it's not voluntary. If you're not willing to do that, the next step is working with some sort of opting in, opting out, or saying, okay, I want this information to be shielded or not to be shown. But you, as a register, still, as a GTLD, still need to have that information for contractual purposes, for fulfilling your contract, or etc. So, and also for fulfilling maybe the access requirements by government or by even more complicated rights holders. So one of the solutions could be that you, in the case someone does not want this to be published within WHOIS, that you have a different email address where you know this email address, or not only email address, but an address, where you know, okay, behind this address, which is shown, there's someone else. And an email that goes there would be forwarded to that person where you have the identity. This concept is one that's under the GDPR. It's called pseudonymization, terrible word. But what it means is there's someone who can actually allocate one address to really individual persons while not displaying the right address or not displaying the full information which you have. So that could be a concept that you could use for complying with both ends, with the privacy interests of the individual and with your interests in collecting the information and complying with certain obligations to provide the information. So, and the last one is, do you have to collect opt-in, opt-out, and so on? That's probably actually just following it. In my view, you would actually need to collect an opt-in, a clear consent, some sort of opt-in towards publishing the information of the individual. And the default should be that it's not published. Again, under the GDPR, there's this concept of data scarcity. So anything that is not necessary to publish shouldn't be published. So the general concept should be it's not published only if you're asked to do so. It would be an opt-in toward publishing.
Thanks, Felix. Any other reaction? If not, we can open the floor. Yeah, Roberto.
Hi, Roberto Gaetano, chair of the PIR board, but speak in my personal capacity. There's one aspect of the regulations in terms of privacy and related issues that has not been mentioned that I would like to remind is the data retention provision in the contracts for registrars. That is also at odds with the law in several countries, and that includes Europe. And of course, there's ICANN has put in place a complex waiver that will allow registrar to follow the laws of their own countries, which is, I found a little bit funny. But the question is this one. In other domains, like for instance, tax regulations, the situation is that you have contracts, but those contracts have to be following and compliant with the tax laws of the country where the operator is operating. Full stop. Why is it that for privacy, this is not the situation? So somebody who is operating in one country has this problem of either following the contract or follow the laws of the country or being obliged to ask for a waiver, you know, this kind of things. Basically, the question is, why do we accept the fact that for instance, for tax, but also for other things, the countries, the local law trumps the contracts, whereas for privacy and all those related issues, we are sort of attempting to impose a model, a one-size-fits-all, on the whole world, regardless on whether this is at odds with the national law. Why is it this? Why is that so important to have the same privacy laws everywhere, imposed everywhere, and why is it different from other situations? Thank you.
To anyone in particular or to everyone? The question.
Well, I think that probably the people who have the one foot in Europe and one foot in the US are probably better placed. For sure, the CCTLDs don't have this problem to a certain extent, but
If anyone wants to react.
whoever wants to.
Whoever wants to.
So one of the things why this is actually an issue is because it makes my job interesting. So I'm very happy about the fact that there are all those conflicts of laws. And what you're raising is a conflict of law issue. We have tax law and data retention rules under the tax law. And we have privacy laws which may request different timings. However, for that specific problem of data retention, privacy is not the main issue, because privacy laws for data retention state that the data has to be stored as long as necessary for fulfilling the purpose. And tax laws are being seen as one of the issues where privacy law actually allows you to store that data which you actually need for tax purposes. The problem comes in that tax laws are different across various jurisdictions. So in one country, it's maybe 7 years you need to store it, in the next one it's 10, and sometimes you've just got 2 years. And that's where it's complicated and we get to spaghetti code, because you may have to obey different time settings, and you can't just tell your developer, okay, it's 10 years for everyone stored like this, but you have to differentiate further and go into each country. This is a reason why having one approach towards privacy and is actually a good one. Having one law that would be applicable to everyone, because then you have clear regulation, as Microsoft likes it, as I like it. Clarity is always a good thing. And it's also helping you to have a rather simple solution, and you don't need to differentiate whom to do it for. But so the reason basically is that is not as much in sync as it should be.
And for, like I said earlier, for a company like Microsoft, where to be subject to multiple laws, say on privacy, that may be nuanced or completely different to scale, makes it very difficult. And you get spaghetti code, and then, you know, you drop the spaghetti code on the floor sort of situation where it's just a mess. And so to avoid that, and sometimes I think we recognize that, you know, could potentially be a challenge to actually harmonize everything. But at the same time, like in Europe, it's the notion of adequacy. How do you make sure that the citizens of your country are adequately protected by the laws of the citizens of another country? I think the tax situation, or the tax example that you raised, is an interesting one. But you know, I think to the point, it goes to the, you know, in other areas it might be the unique circumstances and kind of what, you know, is most important. And, you know, even under the Privacy Shield, there's this notion that you can retain data, you know, for the legitimate, you know, if there's a legitimate reason to do so, to avoid the situation where you're just collecting as much data as you can, because there's also kind of that sort of limitation. You collect it for the purpose that you need it for, and then you want to keep it for as long as you can, just, you know, in some cases because, and how do you get around that sort of thing? And so, you know, that may not apply in other circumstances, but it seems to make sense and work in the privacy context.
Any other reaction? We have 3 more at least questions, so we can go ahead.
Good morning, everybody. My name is Adlan. All of us know how is the privacy, who is conflict with a lot of country laws, especially for Europe region. And all our conversation here at the end impact on end user or citizen. So my question will be from citizen or end user side. Please, from your view, what's the role of the citizen regarding this issue? And the second question is, does the DNS industry partner increase or do enough work to increase the awareness for citizen? Thank you.
Anyone? Byron.
Maybe I'll take a stab at least the second part of the question. Does the DNS industry attempt to help educate? And I would say absolutely yes. Certainly from our perspective as an operator in country, but also there are organizations like DNA who are trying to do it more globally. That said, it's a complicated space for the average end user. They don't think about it, they don't understand it. I mean, if you want to kill a cocktail conversation, say as an intro, oh, I'm in the DNS industry, and quickly you'll find yourself in a corner by yourself. That said, you know, most CCTLDs or many CCTLDs and others in our space go to great lengths, at least as far as their resources are concerned, to try and educate, to try and provide information. If you go on DENIC's site or my site or many others, you'll find much information about it and aimed at the end user. But it's an area that the end user typically doesn't think about, doesn't care about. I turn my machine on, turn my computer on, my iPad, whatever. As long as it works, I'm not thinking about the DNS. And that's one of the challenges that we find as the operator community, as the CCTLD, who you know, we often have mandates greater than just matching names to numbers. And it's an ongoing struggle and challenge, though we do try to do it.
Okay, go ahead.
Thank you. I'm Jay Daly. I'm the Chief Exec of the .NZ registry. The new GDPR includes a right to erasure, and I'm curious to understand how people think that will affect GTLDs if it becomes more common or if it becomes something that is available effectively on demand once somebody's registration has been cancelled.
I don't want to talk all the time, but I'll take that one. It's quite a legal question, I think. So the right to erasure is a claim that the customer can make, or the former customer in this case, to request that data is deleted. This deletion request is sometimes extremely difficult to fulfill. Specifically, again, if your system hasn't been built for ever deleting data, but basically just sums up what you have. Plus, you may actually need the data for at least for a while, because you may want to go back to this customer, or you may get an inquiry about which you need to fulfill. So there is a retention, potential retention obligation colliding with that right to erasure. The way it's solved is that alternatively to completely deleting the data, there's also the concept of blocking the data. So while it may not be possible to delete it for various reasons, and I don't know many companies that really have gotten data deletion right and data retention completely right, because it's so difficult. It could be sufficient just to block it from access. So blocking means that it cannot be accessed by everyone, but only by very few in the company, and it could be encrypted, or there could be some additional layer over it, plus you have access rights. So it could be that you simply need to flag that information, flag it for some sort of override or something like that, still have it in your database, but it wouldn't be accessible to everyone. That could be a solution. it's probably something where you need to be rather creative about looking into what you have as your system and how to adapt it to that rule.
Jörg?
I may want to add something to that, Jay. Actually, we are being confronted by the problem even right now. So it's not something very new coming up with GDPR. With respect to the DNS, not a problem. Well, you can just erase the data set and that's okay. More than that, it's becoming a little bit more critical if you do want to keep domain name histories, for example, to settle any kind of rights problem. And this is exactly what we are doing right now. We are saying we need to keep the data to settle any kind of rights issues or whatever a history is needed for. And I feel that currently this is not in conflict with German data protection rules. At least we've been talking about this way forward with our local data protection officer, and they agreed for us to do so, like I just said. So it's probably not so problematic. It's something that is conflicting within data protection. It's the purpose, on one hand, you're collecting data for, and it's a retention time or the retention guideline you need to fulfill as well. And those are conflicting, and you can argue about which one is more priority to your operation.
We have one more here and another here.
Thank you. My name is Anne-Marie Pecoraro. I'm an European IT lawyer and member of the Advisory Council of PIR. So this is a question for Mr. Torres. You explained very clearly the evolution of the situation, and the EU moved from the safe harbor to the privacy shield to improve the situation of the citizen. But how is it concretely an improvement? Why this transition should be better for the privacy? Because we don't see exactly the movement to an improvement from one system to the other system. And the other question is for a global company such as yours. When there is an improvement in one zone, in the European zone, does it lead your company to improve or to change worldwide as the activity is global?
Well, I'll answer the second question first. Yes, certainly for our compliance efforts to meet the Privacy Shield requirements, what's coming out under the GDPR, we would do that in a way that applies globally. Now, as I said earlier, for us, we may have been positioned slightly differently, just given our company's stance on privacy. For a long time, we've supported a comprehensive privacy legislation here in the United States. We thought that was very important towards customer trust. We've pursued that for a number of years now. Unfortunately, given the Congress and other issues that have come up, that effort hasn't really flourished as we and some other companies had hoped. Certainly our administration here in the United States has taken privacy seriously. They put out a blueprint for legislation and all of that. But to get back to your question, yes, we wouldn't just say we're going to apply those rules just to our customers in Europe. We would sort out how to do that, but in a way that applies across the board, in part to avoid the spaghetti code issue and to get to scale. And that's something that we look at and take very seriously. In looking at the safe harbor versus the privacy shield, even before the Snowden revelations, I believe there was talk about, the privacy shield was done in 1996. Certainly the technology and the landscape has changed since then. It's probably an appropriate time to take a look at the requirements there. Just in terms of that and making improvements, one of the aspects of the privacy shield that we have called out is the notion of an annual review. So this thing will not, so that rules won't stay static, that they'll be evaluated as technology changes. There's this flexibility, and so we appreciate that. As far as making improvements, certainly around government surveillance, there was provisions and assurances from the U.S. government that certain things wouldn't happen, including kind of the just bulk collection and some other aspects of that. There's more specificity around a redress mechanism, an independent redress mechanism, and we thought that was important. I think that data retention, people understood that was the direction. The notion of course, under the safe harbor and again under the privacy shield, the notion of self-certification, but there were questions about how to make that enforceable, and certainly the requirements of providing certain things in your privacy policy, which then our Federal Trade Commission could enforce against, added some robustness there to the enforcement ability. And there's also the ability of complaints being filed with the Department of Commerce if certain things, conditions aren't met. There's independent oversight. And I know there was some back and forth about kind of what that means. Just my sense, and this is just me talking personally, is that the European notion of independent oversight means establishing a complete independent body. Here we have kind of public auditors and people positioned actually within agencies that serve that sort of independent role. And I believe that the role in this case is, sits at the Department of State, who will serve that function and role, and that was something new that wasn't in the safe harbor. Again, to provide assurances that if a European citizen has a complaint about how their data may have been used by a company availing themselves of the safe harbor to allow for this transfer, that their complaints get a fair hearing and get heard, and that there's a mechanism, easy mechanism, going to the company. If the company doesn't resolve it, ADR. If the ADR doesn't resolve it, there's this independent kind of authority that you could take it to so that your complaint gets resolved. And of course, like I said, in the case of Microsoft, we just, we've come to the realization for quite some time that we've got a large presence in Europe, and that we were willing to subject ourselves to the DPA, working with the DPAs to resolve this. So that's the avenue that we took.
Thanks, Frank. We have 2 more questions, 13 minutes left, so if anyone wants to add another question, it's now the moment, here and there.
Thank you. I'm David Abrahams. I'm from Nominet in the UK. I wanted to make an observation, which is we've spent a lot of time discussing the duality of privacy regulation in the United States and European Union. And I think that in the new GTLD world, we actually have a very significant third player in there, which is China. And the regulations for registries and for registrars for some of the new GTLDs in relation to selling those and making them active in China is now very, very significant. Now, those apply to Chinese registrants rather than registrants around the rest of the world. But I think we're going to increasingly, in the industry, need to take account of this third very significant body of regulation.
Thank you. Any reaction? Another question?
My name is Saf Philly, member of Internet Society, Washington, D.C. I'm from Sierra Leone, West Africa. My question is for you. The continent of Africa has 1.3 billion. Is there any effective link, African countries and the continent, with European, the DNS with European countries? The question is for you. Is there any effective link of African countries, their DNS, with Europe and America?
Yes, there is. So, as we've discussed the privacy shield all the time, that's only a solution for the US. It's not for any of the other countries. And if you're providing a service from another country, you have to find another solution. And that's sometimes very difficult. So there's a significant impact on African companies as well. If you deal with European data, that's the second thing. So if you have only customers that are in your country, it's not that much of an issue, because in that case you wouldn't deal with data of Europeans and it's not applicable. However, if you have just one European customer that's also using your domain, and you know this is data in Europe, then the whole breadth of the European regulation comes into your company as well. So that's the one part of it. It may in part be theoretical, however, it's maybe quite important, because if you want to grow your business, if you want to be more, if you don't want to offer a local service, but if you want to offer it more on a worldwide level, and say there are opportunities to use it on a broader scale, it's probably advisable to build what you have in a way that it does comply with as many laws as possible at the same time, which would include the European rules, because they're quite strict. And an approach that I see many companies taking is that they're saying we're taking the strictest approach, and we try to apply that across all of our customers, even if it's not applicable to many of them. And so that's how it comes into play, that in this case Europe is actually exporting a standard to other countries, whether they like it or not. It may be advisable to follow it, and even if they complain about it and say it's not a good idea for us.
Any more questions? Sorry. So there's no. I was surprised. I thought there would have been more questions, but this is better because we have more time for a final comment from anyone or everyone from the panel. So if you want to get a final message, a couple of minutes, it's your turn.
Well, probably have more of an observation than a final message, and I think it's very interesting to see that we are talking about data privacy and how we are dealing with that, where on the other hand, aside of the DNS industry, we're talking about big data, we're talking about the oil of the future, which is data, and I'm just wondering about the contradiction. So on one hand, be more restrictive with data and implementing data protection laws, and on the other hand, we, and not only we, but all the other industries around us, we are focusing and we are moving in a direction where we want to analyze data instead of keeping it too private. So there's, once again, a very scarce balance to strike between what kind of data we use and what kind of data we can't use. Probably that is leading to the concept of data sovereignty, and we haven't been talking about that as well. Probably that is part of a new panel coming up next year.
So if I could just add to that's you just raised, I think, one of the major questions that not just this industry but across industries is facing moving forward, and how do you strike the balance between being able to use the data for analytics and other purposes to benefit, again, enterprise and customers and society, and do all those sorts of things, but in a way that is respectful of people's privacy, allows them for some choice, some consent, all the privacy principles that the regulators and others have talked about for a long, long time. The notion of privacy is a human right, and what that means against the backdrop of all the benefits that technology and the data analytics can bring. And I think that's a question for dialogue and discussion and perhaps even debate that it's very important to have amongst all the stakeholders to get there. It's almost as though, and I've talked to my colleagues about this, it's the oft-used phrase here is you're at a kind of an inflection point. In which direction do you want to head in, for allowance of innovation or something where, the information gets shut down in ways that aren't necessarily helpful or good.
Thanks, and Jörg brings up an idea that we've been thinking about, and I think it was the chair of PIR also raised the question, we have tax regimes, and how is that different from the regimes that we're talking about here? And one of I think the great challenges that, we especially in this room face, because we're the ones arguably thinking about it at relatively leading edge, is most of the systems that we have in terms of governance or government are, in a sense, systems that go back to Westphalian. We've been living in a Westphalian regime for centuries, and those systems have been worked out and discussed and argued and fought over and in place literally for centuries, like taxation, even though there are always ebbs and flows in it. Those are essentially worked out environments, and part of that is accepting the notion of being a citizen of a nation. And yet the internet, writ large, is in a sense the first system that is truly global and indifferent to borders, truly borderless, and to some degree permissionless. And there's the rub and the contrast and the friction point. We have these two systems, and in one we're citizens of a nation, and on the other we're global citizens. And there's benefits to that, and there's challenges to that, and we're at the forefront of trying to wrestle those policy differences down. And I don't have the answer yet, absolutely, but I think it makes for
such a pity.
Fascinating, yeah, I wish, fascinating discussion, but also challenging discussion as to how do we wrestle these difficult questions down to the mat between a global permissionless, borderless system of the internet and centuries of national jurisdictions and other systems and policy environments.
Do you want
Felix? I think, Byron, you bring up a very good point, because it's basically what it boils down to is an ethical approach. And it's about company ethics, how you want to take certain things forward, how do you balance business interest and the use of big data, for example, and any of those systems, and it's a wealth of data that is collected by many. How do you balance that with the ethical question of how do you treat an individual and their data? And this, again, working from the Silicon Valley at the moment, most of those clients there would probably say, well, we just do it and see, and then we look later. So we'll just analyze the data and then we try to come to compliance, which is one approach. It could also be that you think about it initially and come up with some own steer towards it, and that's different, and that's also culturally different in various countries. But that's basically what I think is the interesting part of it. It's not only down to what does the law exactly say, and is there any way around it. It's basically to finding an elegant approach of making the best with the data. It could be also the individual or the business best, but finding what you can do and setting that in relation to privacy, and that'll give you a good solution.
So this was much better closing than it would have been planned. So I will end here 1 minute before the break. So thank you everyone for coming, and thank you for the panelists. I want an applause for them.